Hello, everyone. Today, myself, Nikhil Ramdev, Senior Associate at MRP Advisory. Today, I'll be hosting the discussion uh, on the recent government guidelines issued by Government of India on mediation and arbitration. I'm pleased to introduce Ms. Srividhya Ragavan. She's Professor of Law and Director of International Program, Texas A&M University School of Law. Thank you, Shri Vidya, for being with us today. Before we start with the topic, can you please briefly introduce yourself?
Sure. Hi, my name is Srividhya Ragavan. I'm a professor of law and director of international programs at Texas A&M University School of Law. My work specializes on intellectual property, international trade, and other areas that implicate it, including dispute resolution, such as arbitration and so on. In that capacity, I'm happy to talk about one of my recent works that the arbitration regime with Mr. Ramdev. Thank you.
Thank you so much. So, please let us know what do you think about ADR, how it works in other areas of law like IP.
Dispute resolution, especially quick resolution of disputes, has become important in several contexts, right? It's important to enable trade, enable investments, for private company, with some reasonable level of certainty and resolution of disputes in a timely manner and in a systematic manner has become an important aspect of international trade and conduct of business. So intellectual property rights it forms a part of our international trade regime, of which countries like India are all members, the international trade regime under the World Trade Organization, and dispute resolution and reasonably dispute is an aspect of the trade regime. In terms of arbitration, arbitration is one of the alternate dispute mechanisms that the globe has been working with. Part of the reason is because of the issues with judicial the issues it takes for judicial resolution of disputes, which varies from country to country, that implicate judicial resolution. So over time, both arbitration as well as mediation, which allows for disputes to be mediated and settled well, have both become potent resolution alternate mechanisms of dispute resolution, which feeds into both all areas of international trade, particularly intellectual property rights.
Thank you so much for your insight. So, as you know, the Government of India has recently issued guidelines that recommend use of mediation over arbitration for disputes worth more than 10 crores. What is your take on the new guidelines?
So the new guidelines, in some ways, does not comport or is not in sync with the international posture on dispute resolution. The international posture on dispute resolution is to go for arbitration as the preferred method, because arbitration for resolution of disputes, those that go over 10 crores. Part of the reason is because arbitration is a little more streamlined. Arbitration allows for experts to be arbitrators, and arbitration allows for evidence to be collected in a different manner, etc. So the rest of the world is it goes with arbitration. I am not opposed to mediation, nor do I think mediation is any less than arbitration, but it is a fact that important for other areas for which we do employ mediation, and that has to be supported. But to take away arbitration and supplant it with mediation, to me, it may not be the best way to go forward. Instead, finding a way to enforce arbitral awards in a more sort of standardized, reasonable manner within a reasonable period of time may be the way to follow the rest of the globe. It'll also comport with India's ambitions of becoming an arbitral hub, which our government has repeatedly, the Indian government has repeatedly emphasized.
Yeah.
Thank you.
Thank you. So, what do you think will be the challenges uh, you foresee in implementation of these new guidelines?
Some of the challenges, I believe, will come from the arbitration bar itself. The arbitration bar is a fairly, well-established set of, attorneys in India, and so I would expect, they would, they would shun away from this a little implementation of these guidelines. High value disputes are tougher to mediate because it involves more money. And if they could have been mediated, I think they would have been settled. You get into arbitration partly because settlement was not possible in these areas. And so I believe that to some extent, the challenge would be to seek the type of settlement that would have failed in the first place for parties to come to mediation. The second is it relegates arbitration to a sort of stepsisterly sort of position. And so with well tuned into the arbitration regime and who expect enforcement of arbitration awards in a timely manner, foreign investors would shy away if they know that they can only mediate or go to court, which in India takes a notoriously long time to resolve. So that could affect foreign investments, foreign investments into India.
Thank you. So, with this shift towards mediation, what changes, if any, do you believe are necessary in legal education and training for arbitration and dispute resolution professionals and students?
Whether we shift into mediation or not, I believe we need training in both mediation as well as arbitration. And I believe that should be universal training for all different invested constituents, which includes students, professors, legal executives, law firms. I do find that sometimes judiciary in India has balked at arbitration awards, which seem otherwise perfectly fine. And so I believe that there has to be universal training in all of these areas, and also on areas where arbitration and mediation could be used effectively, such as can IP disputes be arbitrated? What type of questions can be arbitrated? Not all types of not policy can be arbitrated away, but questions that have a privity can go into either arbitration or mediation. Now, with the guidelines in place, of course, there has to be a shift in trying to use mediation as the first resort, and probably use in countries or, investors who insist on arbitration will have to go into a more sort of global arbitration system, such as the Singapore arbitration or UK arbitration. So I believe training in mediation, what type, and completing the mediation in a timely manner, and from mediation, what is the next step? These are all areas where education should be imparted. And then the type of questions that can be arbitrated. If India is not going to be the hub for arbitration, then training Indian arbitration bar in foreign arbitration systems, which some of us were hoping would not be required, is also important. And last, I think training on these arbitral awards, whether Indian or foreign arbitral awards, because recent cases have taken about 12 to 15 years to just enforce an arbitration award. There have been arbitral awards that have been given after about like 6 years, which I think the entire idea of our alternate dispute resolution is to be more reasonable in terms of time period. And so, training and education on all of these matters has become very, very important.
Yes. Thank you. So my next question is, how does India's emphasis on mediation compare to the trends in other countries? Are there lessons that India could learn from international practices in mediation?
And yes, all countries are now shifting to all dispute settlement mechanism, mediation being one of them, all forms of, I want to say, alternate dispute settlement mechanism, absolutely one of the mechanisms. And yes, India, I believe, not just India, I believe all countries should get trained on best practices, in mediation, especially for countries like India. It helps to be trained on, where mediators come in, the role of the mediators, as well as the limits of mediation, right? As well as how mediators can to that, to that medium or whatever, the center line settlement, how they can push both parties towards a reasonable settlement within a reasonable period of time. I think that has to be underscored. Can all be areas. Of course, the mechanics, the procedures of mediation is also an important aspect, and where mediation can be successfully deployed. These are all important aspects. Now, there are, different academic institutions, the role of mediation in dispute settlement. I believe that these institutions can provide high-level training on these areas. Thank you.
Thank you so much. So my last question is, looking ahead, how do you see the landscape of dispute resolution evolving in India over the next few years with the new guidelines in place?
So the dispute resolution has to evolve in India, right? Whether it's judicial, whether it's alternate dispute resolution, accommodate the global trends, the global trade regime. Otherwise, this area alone will drag the country down, because investors, whether foreign, Indian, small, medium, or large, will hesitate to invest in a country where the judiciary takes years, more than decades, right, with no stability, right, to resolve disputes, where arbitration is not available as a, as a potent alternative. These do choose to go to arbitration, enforcement locally becomes an issue. And then where the guidelines posit mediation for, high value disputes going against the global trend. So that, it has to evolve in a manner that accommodates the, the global trends in this. With the guidelines in place, I believe the guidelines have to position all of this to be resolved in a more sort of timely manner and in a more systematic, with a standardized process that creates, that sets expectations right for both global as well as local investors. Thank you.
Thank you so much for taking out time and being with us today. And it was a pleasure to have you with us. Thank you.